Okay, let's talk about something that can be incredibly stressful. The police want to interview you about a privacy allegation. Your head's probably spinning, right? Well, in this explainer, we're going to cut right through all that confusion. We'll give you the essential information you absolutely need to figure out what comes next. So, you get that call. Or maybe that knock on the door. The police want to ask you some questions. Your mind is just racing, and you're trying to figure out the right thing to do. What is your absolute first, most critical move? Right here. This is it. This is the single most important thing you can possibly hear. It doesn't matter if you know you're innocent or if you think you have the perfect explanation. Following this one rule is your strongest, and I mean most critical, form of protection, period. So why is that advice so important? Well, to get that, we need to dig into the specific law that's probably at the heart of all of this, Section 227A of the Queensland Criminal Code. What this law really does, at its core, is protect people from being watched or recorded when they have a reasonable expectation of privacy. You can think of it as a safeguard against unwanted surveillance, which is a huge deal in our digital world. It covers, everything from photos to videos and even audio recordings. For the police to actually make a charge like this stick, they've got to prove three key things. First, pretty obvious, there has to be some kind of observation or a recording. Second, the person in that recording, well, they didn't agree to it. They didn't give their consent. And third, and this is really the one where things get complicated, it has to have happened somewhere a person would reasonably expect to have privacy. That phrase, reasonable expectation of privacy, I know it can feel a little vague. So what does it actually look like in the real world? The thing is, the law isn't black and white here. It's all about the context. So let's look at a few examples. Just think about how our idea of privacy changes depending on where we are. Say you're on a public beach. Your general expectation of privacy is pretty low. But even there, if someone starts zooming in and filming your private regions, the law can step in. Now, contrast that with your own backyard. Your expectation is way higher. And inside your home, that's your fortress. That's where you have the highest level of privacy. It just goes to show you how the exact same action, filming, can be totally fine in one place and a criminal offense in another. So understanding the law is one thing, but it's really the potential consequences that drive home just how serious this is, and why getting that legal advice from the get-go is totally non-negotiable. Let's be crystal clear about this. This is not a minor slap on the wrist. It's not like a parking ticket. A charge under Section 227A is a formal criminal offense. And if you're found guilty, you will most likely have a criminal conviction on your record. And the maximum penalty? It's significant. We're talking about a potential sentence of up to 3 years in prison. That is a truly life-altering consequence. And it's not like there's a simple formula for sentencing. A court is going to look at a whole bunch of different factors. Things like, what was your intention? Do you have a criminal history? How many recordings were there? Was it a sophisticated setup? This complexity is exactly why you need an expert to help you navigate the whole process. Facing something like this can feel incredibly isolating. But it's so important to know that there are ways to defend yourself. But, and this is a big but, these are not paths you should ever try to walk down on your own. A lawyer is going to explore a few different strategies. For example, they might argue that the recording was a complete accident, that there was zero criminal intent. Or maybe they can show that the person being recorded actually gave their consent. These are really nuanced legal arguments, and you need serious expertise to present them effectively. And then there's all this critical stuff that happens behind the scenes. One of those is something called case conferencing. This is where your lawyer gets to formally negotiate with the police prosecutor. It's their chance to present your side and argue for the charge to be dropped entirely, long before it ever gets near a courtroom. It's a hugely important step, and it's impossible to do without a lawyer. Look, it is worth repeating this because it's so fundamental. The police have a job to do. That job is to investigate a potential crime. They are not there to help you build your defense. Their entire goal is to gather evidence, and literally anything you say can and will become part of that evidence against you. Okay, so we've gone through the law, the potential risks, and the legal process. Let's pull it all together and really focus on the absolute key things you need to walk away with. So let's boil it all down. 4 things you absolutely have to remember. 1, being innocent won't stop you from accidentally saying the wrong thing. It happens. 2, this stuff is complex, and the penalties, they're no joke.
3, a lawyer is the only one who can get their hands on the full police evidence brief so you can actually see what they think they have on you. And finally, your right to silence, it's not a sign of guilt. It is a shield, a legal protection, so you need to use it.
And that really brings us to the final crucial question here. Understanding the basics of the law is a fantastic first step, but navigating the justice system, that requires a deep understanding of your rights and exactly how to protect them. The absolute smartest move is always to make sure you have an expert in your corner before you do anything else.